Hello everyone, welcome back to channel US Immigration News. We hope you're doing great. Well, in today's video, we'll be talking about immigration court backlog crisis could make mass deportation inevitable.
Hello everyone. Whoa! Welcome back to our channel US Immigration News. We hope you're doing great. Well, in today's video, we will be talking about immigration court backlog crisis could make mass deportations inevitable. The immigration court backlog in the United States has reached a staggering 2 million cases, prompting fears that mass deportations could soon become inevitable. As the system becomes increasingly overwhelmed, many individuals facing removal may find themselves without timely legal recourse, leading to potentially unjust outcomes. This video underscores the urgent need for comprehensive reforms to protect vulnerable populations seeking safety and stability in the U.S. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So without any further delay, let's jump into the video. At the OCT 11 campaign rally in Aurora, Colorado, former President Donald Trump announced that if he is elected again, he will use the Alien Enemies Act of 1798 to conduct mass deportations of undocumented immigrant criminals. The act does not require individualized notice or a hearing, nor does it give an opportunity for the immigrant to appeal a decision. And it does not specify a burden of proof that the government must satisfy. Are mass deportations under the Alien Enemies Act necessary? Unfortunately, there doesn't seem to be an alternative. The Biden-Harris administration has overwhelmed our immigration courts by bypassing the visa system to release more than 5.4 million inadmissible migrants into the U.S. and failing to apprehend approximately 1.9 million gotaways. This has caused a massive increase in the immigration courts backlog. It was just under 1.3 million cases when the Biden-Harris administration began, and as of the end of September, it had risen to more than 3.7 cases. A track immigration report released on Sept. 20 states that it is no longer possible to estimate wait times for appearing before an immigration judge. Too many of the migrants waiting for removal proceedings haven't been scheduled for a hearing yet. The situation is aggravated by the Biden-Harris administration's failure to ensure that the deportation orders the judges issue in removal proceedings are executed. In fiscal 2023, Immigration and Customs Enforcement, the agency charged with enforcing our immigration laws in the interior of the country, was only able to remove 142,580 11% of the 1,292,830 immigrants already subject to final deportation orders. The absence of meaningful interior enforcement encourages illegal border crossers to keep trying until they succeed in reaching the interior. Congress did not directly regulate immigration before 1798. It left this up to the states, with each maintaining its immigration laws. This did not change until there was an undeclared war against France. Federal officials thought a French invasion was imminent and were afraid that French sympathizers in the U.S. would support it. The Alien Enemies Act was enacted to permit the president to summarily deport French nationals living in the United States. More than 200 years have passed since then, but its statutory provisions have not been changed significantly. The president can invoke this authority with a proclamation whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government. Some politicians contend that authority under the Alien Enemies Act can be used to address unlawful migration and drug trafficking, which they describe as a rhetorical invasion or predatory incursion. The Alien Enemies Act has only been used when Congress has declared war, so there is no case law interpreting the meaning of invasion or predatory incursion. According to Catherine Yon Ebright, a counsel in the Brennan Center's Liberty and National Security Program, there is no plausible basis for saying that migration or narcotics trafficking constitutes an invasion or predatory incursion. But that doesn't mean that the courts will intercede if a president invokes the Alien Enemies Act on that basis. The courts might treat a president's finding that an increase in migration or narcotics trafficking constitutes an invasion as final and unreviewable under the political question doctrine. This doctrine provides that an issue may be so politically charged that federal courts, which are an apolitical branch of government, should not adjudicate it. The last time the Alien Enemies Act was challenged in Ludecky v. Watkins in 1948, the Supreme Court upheld President Harry S. Truman's extended reliance on the law 3 years after the end of World War II, says Yon Ebright. The court reasoned that the question of when a war terminates and wartime authorities expire is too political for judicial resolution. Does this mean that Trump's intended use of the Alien Enemies Act would withstand judicial scrutiny? In any case, his decision to conduct mass deportations under that act would be litigated by the Supreme Court, as was the case with his travel ban. CNN claims that Trump is making false statements about how many migrants with criminal records the Biden-Harris administration is releasing into the country. That may be true, but CNN is missing the point, namely, that there are too many undocumented migrants in the United States who are dangerous criminals. According to a letter from an ICE deputy director, as of July 21, 2024, there were 662,566 undocumented immigrants in the United States with criminal histories. This includes 435,719 convictions and 226,847 pending charges. Their offenses include 13,099 homicides, 15,811 sexual assaults, 2,521 kidnappings, 13,423 weapon offenses, 10,031 robberies, 56,533 dangerous drug offenses, 14,301 burglaries, and 62,231 burglaries, and 62,231. The Biden-Harris administration has had almost 4 years to remove the deportable migrants in that group, and the offenses indicate that many of them are deportable. But neither Biden nor Harris did. They have let more than 7 million illegal border crossers into the country that little, if anything, is known about. Frankly, we don't understand why they haven't deported the undocumented immigrants who are dangerous criminals. They stopped enforcing immigration laws against undocumented immigrants who are just here illegally so they could focus their resources on deportable migrants who pose a threat to national security, public safety, and border security. Aren't dangerous criminals a threat to public safety? If Congress doesn't pass legislation to end the practice of bypassing the visa system to let migrants who can't get visas into the country, future administrations will have no alternative to resorting to extreme measures like the Alien Enemies Act, regardless of party affiliation. And if Kamala Harris is our next president, and she continues the Biden-Harris administration's immigration policies, the backlog is likely to get much worse. In summary, the immigration court backlog crisis poses a significant threat that could result in mass deportations. With an overwhelmed system and prolonged case processing times, individuals at risk of removal may face dire consequences. Immediate action is needed to address this backlog and ensure that justice is served for those seeking a better life in America. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
At a campaign rally on October 11 in Aurora, Colorado, former President Donald Trump announced his intention to utilize the Alien Enemies Act of 1798 for mass deportation of undocumented immigrants with criminal backgrounds if re-elected. This act allows for deportation without the due process of individualized notice, hearings, or appeals and does not require the government to meet any specific burden of proof. Critics question whether such drastic measures are necessary, particularly given the Biden-Harris administration handling of immigration, which has exacerbated an already overwhelmed court system. Since the Biden-Harris administration took office, over 5.4 million inadmissible migrants have been released into the US, contributing to a staggering increase in the immigration court backlog, which rose from under 1.3 million cases to more than 3.7 million by the end of September. A report from Track Immigration highlights the severity of the situation, noting that many migrants have yet to be scheduled for hearings, making it impossible to estimate wait times. The administration's failure to enforce deportation orders issued by judges further complicates the crisis. In fiscal year 2023, ICE could only remove 142,550 of the 1,292,830 immigrants who had final deportation orders. This lack of effective interior enforcement encourages further illegal crossing, as many believe they can evade consequences. Historically, the Alien Enemies Act was enacted during an undeclared war against France to allow for the deportation of French nationals in the US. It grants the president authority to summarily deport individuals during the times of declared war or perceived threats to national security. Some politicians argue that current levels of illegal migration and drug trafficking could be classified as a rhetorical invasion, justifying the use of act. However, experts like Catherine Yon Ebright contend that the migration does not equate to an invasion and question the legal ground for using this act in contemporary immigration policy. Despite concerns over potential legal challenges, there is a possibility that courts could defer a president's interpretation of migration levels as an invasion under the political question doctrine. Past cases such as Ludeque v. Watkins in 1948 have shown that the Supreme Court may uphold the use of wartime powers even when their relevance is debated. Additionally, Trump's claim about the number of criminal migrants being released by the Biden administration have drawn scrutiny. As of July 2024, there were over 662,000 undocumented immigrants with criminal histories in the US. As of July 2024, there were over 662,000 undocumented immigrants with criminal histories in the US, many of whom have committed serious offenses. Critics argue that the Biden administration has failed to act on deportable individuals, creating a public safety concern. The pressing need for legislative action to reform immigration practices is evident. If Congress does not act to eliminate the current approach that bypasses the visa system, future administrations may resort to extreme measures like the Alien Enemies Act, regardless of political affiliation. Without significant changes, the backlog and associated risk will likely worsen, potentially endangering public safety and national security.